Good morning.
Good morning.
The Judiciary Committee will come to order, and without objection, the Chair is authorized to declare a recess of the committee at any time. Pursuant to notice, I now call up S 1890 for purposes of markup and move that the committee report the bill favorably to the House. The clerk will report the bill.
S 1890 to amend Chapter 90 of Title 18, United States Code to provide federal jurisdiction for the theft of trade secrets and for other purposes.
Without objection, the bill is considered as read and open for amendment at any point. I'll begin by recognizing myself for an opening statement. Today we are here to mark up S 1890, the Defend Trade Secrets Act of 2016. The bill puts forward modest enhancements to our federal trade secrets law, creating a federal civil remedy for trade secret misappropriation that will help American innovators protect their intellectual property from criminal theft by foreign agents and those engaging in economic espionage. This bill will help U.S. competitiveness, job creation, and our economy. Trade secrets occupy a unique place in the IP portfolios of our most innovative companies. They can include confidential formulas, manufacturing techniques, and even customer lists. Examples of trade secrets include the formula for Coca-Cola and the Colonel's secret recipe. But because they are unregistered and not formally reviewed like patents, there are no limitations on discovering a trade secret by fair, lawful methods such as reverse engineering or independent development. In innovative industries, that is simply the free market at work. Though trade secrets are not formally reviewed, they are protected from misappropriation, which includes obtaining the trade secret through improper or unlawful means, and misappropriation can take many forms, whether it is an employee selling blueprints to a competitor or a foreign agent hacking into a server. In addition, one could argue that even a foreign government's policies to require forced technology transfer is a form of misappropriation. Though most states base their trade secret laws on the Uniform Trade Secrets Act, the federal government protects trade secrets through the Economic Espionage Act. In the 112th Congress, this committee helped enact two pieces of legislation to improve the protection of trade secrets. And in the 113th Congress, we introduced and passed the first version of this trade secrets bill out of the committee unanimously. Today we are taking up the Senate's corollary bill to the House trade secrets legislation. The Senate-passed bill also includes several important updates. The Senate-passed bill provides that only the owner of a trade secret may bring a civil action for the secret's misappropriation, reduces the period of limitations from 5 to 3 years to align with the USTA, and amends the definitions of trade secret and improper means. The bill also makes clear that ex parte seizures are only available in extraordinary circumstances and places other limitations on the breadth of seizures. The bill further clarifies the appropriate scope of injunctions relating to employment to ensure that court orders are not contrary to applicable state laws. Finally, the Senate bill adds language expressing the sense of Congress that it is important to balance the interests of all parties when issuing an ex parte seizure and instructing the Federal Judicial Center to develop best practices for the execution of seizures and the storage of seized information. The bill also includes a provision to provide protection to whistleblowers who disclose trade secrets to law enforcement in confidence for the purpose of reporting or investigating a suspected violation of the law. These changes were accepted by the Senate Judiciary Committee on a voice vote without objection. Today in this committee we are taking a significant and positive step toward improving our nation's trade secret laws and continuing to build on our important work in this area of intellectual property, and I urge my colleagues to support this bill. It's now my pleasure to recognize the ranking member of the committee, the gentleman from Michigan, Mr. Conyers, for his opening statement.
Thank you, Chairman Goodlatte. Members of the committee, although trade secrets are fundamental to success of any business, United States companies have struggled to protect these valuable assets, especially in a digital age of smartphones and the Internet. S 1890, the Defend Trade Secrets Act of 2016, amends the Economic Espionage Act of 1996 to create a federal civil cause of action and facilitate expedited ex parte seizure of property when necessary to preserve evidence or to prevent dissemination. This is important legislation. Like its House counterpart, enjoys broad bipartisan support. The Senate passed S 1890 by a vote of 87-0 earlier this month, and the House bill, H.R. 3326, which was introduced by our committee colleagues, Representatives Doug Collins and Jerry Nadler, has 155 bipartisan co-sponsors, including myself. I support this legislation for several reasons. To begin with, S 1890 will enhance the protection of trade secrets, which is integral to the success of any business. It is estimated that the value of trade secrets owned by United States companies as of 2009 was approximately $5 trillion. Unfortunately, it is becoming more difficult for American companies to protect trade secrets. The loss of trade secrets as a result of cyber espionage costs these businesses, it's estimated, between $200 billion and $300 billion every year. Thieves take advantage of ever-evolving, innovative technologies to access sensitive trade secret information and to distribute it immediately. While federal law protects other forms of intellectual property by providing access to federal courts for aggrieved parties to seek redress, there is no federal civil cause of action for enforcement of trade secrets protection. S 1890 addresses this need by establishing a federal cause of action for trade secret owners to obtain injunctive and monetary relief, which will be a powerful new tool to protect their intellectual property. Another reason I support this bill is that it would foster uniformity among the states. Although states provide civil remedies for trade secret theft, these laws often fall short when trade secrets are taken across state lines. As a result, businesses that have nationwide operations must deal with various differing state laws, which can be too costly for some businesses. This also prevents businesses from taking full advantage of the rights that they have under the law. This law would provide trade secret owners access to uniform national law and the ability to make their case in federal courts. Finally, I support this bill because it reflects constructive feedback from various stakeholders. Many of us have been working on this legislation for nearly 2 years. It reflects the input from a broad spectrum of stakeholders, and the bill is an excellent example of what can be achieved when there is bipartisan collaboration. And so I am pleased to urge my colleagues to join us in support of the legislation. And Mr. Chairman, I yield back the balance of my time.
Thank you, Mr. Conyers. And without objection, all other members' opening statements will be made a part of the record. Are there any amendments to S 1890? For purpose, the gentleman from Georgia seek recognition.
Move strike last word, Mr. Chairman.
Gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. And I want to thank you for holding today's markup of S 1890, the Defend Trade Secrets Act. And I appreciate your work and that of Mr. Conyers in bringing this bill forward. I also want to thank my friend from New York, Mr. Nadler, and Mr. Jeffries as well for their leadership and work on this bill. It has been a long time coming, and we have worked diligently at this, and I think it's a great example of how we can work together to move good legislation forward. I'd like to request unanimous consent to submit the letters of support from the San Jose Silicon Valley Chamber of Commerce, the National Association of Manufacturers, and a coalition letter from more than 45 businesses and groups for the record.
Without objection, it will be made a part of the record.
The Defend Trade Secrets Act passed the Senate by a vote of 87-0. The House companion has more than 150 co-sponsors, including the majority of the members of this committee. Trade secrets are a critical form of intellectual property, yet they don't enjoy the same protections that apply to other forms of intellectual property, such as copyrights, patents, and trademarks. Trade secrets include everything from business information to designs, prototypes, and formulas, but the current lack of a uniform civil remedy for misuse and misappropriation leaves the American companies vulnerable. This means that each year billions of dollars are lost to trade secrets theft. Trade secret theft not only harms the viability of businesses, it deters American innovation, investments in research and development, and American competitiveness. The Defend Trade Secrets Act creates a federal remedy for trade secret misappropriation and provides trade secret owners the ability to make their case in federal courts. It also provides for equitable remedies and the award of damages. In short, the Defend Trade Secrets Act ensures that the innovation can continue to flourish in the United States. It takes important steps to update federal law so that it matches today's needs and establishes intellectual property protections. Today we have a meaningful chance to curb trade secret theft. Passage of this bill means that we are one step closer to preventing the loss of billions of American dollars and the associated jobs. I would encourage my colleagues to support this legislation as it passed the Senate, and I yield back.
Chair thanks the gentleman and thanks him for his good work on this issue. For purposes, the gentleman from New York seek recognition.
Strike the last word, Mr. Chairman.
The gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman, for holding this markup of S. 1890, the Defend Trade Secrets Act of 2016. I also want to thank the gentleman from Georgia, Mr. Collins, for introducing H.R. 3326, the House companion to this important legislation, which will create a federal cause of action for theft of trade secrets. I was proud to join him as the lead Democratic co-sponsor of H.R. 3326, and I appreciate everything that he, Mr. Jeffries, Ranking Member Conyers, and our Senate colleagues, particularly Senators Coons and Hatch, have done to get us to this point today. Mr. Chairman, trade secrets are proprietary business information that derive their value from being and remaining secret. This includes secret recipes, software codes, and manufacturing processes. Information that, if disclosed, could prove ruinous to a company. As the United States continues to grow into a knowledge and service-based economy, trade secrets are increasingly becoming the foundation of businesses across the country, with one estimate placing the value of trade secrets in the U.S. at $5 trillion. Unfortunately, with such fortunes resting on trade secrets, theft of this valuable intellectual property is inevitable. And in today's digital environment, it has never been easier to transfer it across the globe with the click of a cell phone, tablet, or computer key. By one estimate, the American economy loses annually as much as $300 billion or more due to misappropriation of trade secrets, leading to a loss of up to 2.1 million jobs each year. The same report found that trade secret theft is a drag on U.S. economic growth and diminishes the incentive to innovate. With so much at stake, it is absolutely vital that the law includes strong protections against theft of trade secrets. However, our current framework of federal criminal laws and state civil remedies has proven inadequate to the job. Under current law, the federal government may bring criminal prosecutions or request civil injunctive relief under the Economic Espionage Act. While the EEA is an important tool in fighting trade secret theft, the Department of Justice has limited resources and is able to pursue only a very limited number of cases each year. For example, last year the department brought just 15 cases of criminal trade secret theft. In addition, although prosecution does well at punishing perpetrators, it often falls short in compensating victims. Today, a victim of misappropriation must turn to state law to sue for money damages. 47 states and the District of Columbia have enacted the Uniform Trade Secrets Act, while the other 3 states have a similar form of trade secret protection through different laws. While this system has worked relatively well for local and interstate disputes, it has not proven efficient or effective for incidents that cross state and sometimes international borders. Once upon a time, trade secrets might be kept in a file cabinet somewhere, and would-be thieves would have to spirit away a physical copy, making it likely that they would be caught before crossing state lines. But today, trade secrets can be loaded onto a thumb drive and mailed out of state, or even sent electronically anywhere across the globe in an instant. Pursuing a defendant and the evidence in dispute across state lines presents a host of challenges for victims of trade secret theft, particularly when time is of the essence. For example, it can be difficult to facilitate discovery, serve defendants and witnesses, or preserve evidence in a timely fashion when operating across multiple jurisdictions. The need for a federal solution is clear. The Defend Trade Secrets Act would create a uniform federal civil cause of action for misappropriation of trade secrets. It would also provide for expedited ex parte seizure of the property in question but only in extraordinary circumstances where necessary to preserve evidence or to prevent dissemination. The bill we are considering today represents the culmination of over 2 years of negotiations with various stakeholders and has strong bipartisan support. H.R. 3326 has 155 co-sponsors, including most of the members of this committee, and Senate 1890 has 65 co-sponsors in the other body. During the Senate Judiciary Committee's markup, the bill was further improved to harmonize various provisions with the Uniform Trade Secrets Act, providing additional protections for defendants subject to ex parte seizure, preserving mobility of employees, and protecting whistleblowers. This is strong legislation that carefully balances the rights of defendants and the needs of American businesses to protect their most valuable assets. With a yes vote, we can send this on to the House floor and then to the President for his signature. I urge my colleagues to support the bill. I again thank you, Mr. Chairman, and I yield back the balance of my time.
The Chair thanks gentlemen, and the Chair asks unanimous consent to submit for the record a letter from the American Bar Association section of Intellectual Property Law dated October 5, 2015, in support of H.R. 3326, the House companion to the Senate bill. Without objection, will be made a part of the record. For purpose of the gentlewoman from California seek recognition.
To strike the last word.
Gentlewoman is recognized for 5 minutes.
Thank you, Mr. Chairman. I think this is an important piece of legislation, especially since the Senate made significant improvements to the bill that we marked up. One improvement in particular I'd like to mention is language protecting employee mobility by preventing court injunctions that would violate state laws on employee mobility or laws prohibiting anti-compete agreements, which was an issue I raised during the last markup. But I also wanted to mention another amendment that I was working on with my Senate colleagues that would have made changing venue for the post-seizure hearing easier for small companies. Now, for a little company or a startup, it could be difficult to secure counsel and travel across the country in 7 days, and it might be important to have the hearing in a home jurisdiction. I believe that there was agreement in the Senate on the substance of this matter, but there really wasn't time or the possibility procedurally to get it done. Now, I think this bill would be improved with that amendment, but I understand that we want to get this directly to the President. So I don't want to offer the amendment today and create a problem that would prevent this bill from becoming law in an expeditious manner. But, Mr. Chairman, I hope that we might re-examine this issue of small and startups at a later date on whether the venue provisions might be tweaked in some way so that they would have an opportunity to be heard. And I just wanted to mention that concern on the record, although I think the bill is a good one. I'm glad that we're going to send it directly to the floor and to the President with the hopes that we might also attend to this at some later date. And with that, I would yield back.
Chair thanks the gentlewoman. For what purpose does the gentleman from Georgia seek recognition?
Move to strike the last word.
Gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. I'd like to thank Mr. Nadler and also Doug Collins from Georgia, the sponsor of this bill, and I'd like to thank them for their hard work. As a member of the IP subcommittee, I'm pleased to support this legislation that would protect and encourage innovation by helping entrepreneurs protect and capture the benefit of their research and development. My home state of Georgia has experienced exponential growth in the technology sector. The Technology Association of Georgia reports that there are 268,000 Georgians working in the technology fields with a growth rate of 8% per year. Industries specializing in communication services, interactive marketing, financial transactions, logistics, health information technology, information security, energy management, and mission-critical systems have made strong investments in communities across the state. And that's what makes this legislation so important parochially. This legislation will ensure that inventors and innovators in my district and throughout Georgia will continue to focus on technological advancements instead of, or at least with greater assurance that their trade secrets will not be misappropriated. I'd like to ask my colleagues to support this legislation, and I yield back.
Chair thanks the gentleman. For what purpose does the gentleman from New York seek recognition?
Move to strike the last word.
Gentleman's recognized for 5 minutes.
Let me begin by just thanking the chairman and Mr. Collins, Mr. Nadler, as well as Mr. Conyers for all of your leadership in at working together and advancing the Defend Trade Secrets Act of 2016, as well as for the hard work that has been employed over the last few years to develop language that reflects a really balanced approach to dealing with this complicated and important problem that we confront here in America. I also want to thank the coalition of stakeholders who have supported this effort and this bill from the outset and helped us to navigate the really complex landscape of issues necessary in order to arrive at a point where we are prepared to create a federal civil cause of action to combat the growing and significant problem of trade secret misappropriation. As we have often discussed in this committee, strong intellectual property protection is critical for continued American innovation and economic growth, and will continue to serve as an engine for industry and jobs in this country. Trade secrets, of course, are unique among other forms of intellectual property in that once they are stolen or disclosed, their protection is completely gone. Securing and enforcing trade secrets are critical to U.S. businesses across almost every sector of our economy, from the detailed processes of how to make Corning glass or the formula for Coca-Cola to the manufacturing process for Kevlar. Trade secrets pervade every facet of American life. $300 billion is the amount that the U.S. Chamber of Commerce estimates is stolen as a result of trade secret theft and misappropriation each and every year. The Defend Trade Secrets Act of 2016 represents an important milestone to the creation of this federal civil cause of action, and it complements existing federal criminal law in this area. The legislation will allow for the creation of a uniform body of trade secret law, replacing the current and insufficient patchwork of state trade secret laws all throughout the country in an environment where trade secret theft is increasingly multi-state and multinational in nature. The bill, of course, will allow owners to enforce their trade secrets in federal district court directly instead of simply relying on the valiant efforts of our law enforcement community. While law enforcement has been tremendous in this regard, as Director Comey himself has said, the FBI has done its best but can use additional tools in its toolbox when it comes to trade secret theft, and Congress is on the verge of providing our companies with one. Patents, federally registered trademarks, and copyrights are already enforced in district courts, and it only makes sense to include trade secrets within the federal court jurisdiction as well, providing trade secret owners with the ability to exercise nationwide jurisdiction and subpoena power. In closing, this bill, most importantly, provides trade secret rights holders with the ability to seek narrowly tailored civil ex parte seizures under exigent and emergency circumstances. Because trade secret protection disappears at the time of disclosure, an ex parte seizure is essential to prevent unlawful dissemination. Throughout this process, the provision has been strengthened to provide guidance to the federal courts as to when ex parte seizure is warranted, and that is an important improvement in this legislation. The bill has been passed unanimously in the Senate, and today we're taking an incredibly important step forward in the grandest bipartisan tradition of this committee. I thank all my colleagues for their leadership, and I yield back the balance of my time.
Chair thanks the gentleman. Are there any amendments to S. 1890? A reporting quorum being present, the question is on the motion to report the bill S. 1890 favorably to the House. Those in favor respond by saying aye. 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 Those opposed, no. The ayes have it, and the bill is ordered reported favorably. Members will have 2 days to submit views. Pursuant to notice, I now call up S-125 for purposes of markup and move that the committee report the bill favorably to the House. The clerk will report the bill.
S-125 to amend Title I of the Omnibus Crime Control and Safe Streets Act of 1968 to extend the authorization of the Bulletproof Vest Partnership Grant Program through fiscal year 2020 and for other purposes.
Without objection, the bill is considered as read and open for amendment at any point. I'll begin by recognizing myself for an opening statement. Since 1999, the Bulletproof Vest Program, or BVP, has awarded more than 13,000 jurisdictions federal funds for the purchase of over 1 million bulletproof vests. The Bulletproof Vest Grant Program is a critical resource for state and local jurisdictions that have been proven to save lives. This committee has worked tirelessly on criminal justice reform, and we will continue to do so in the future. At the same time, we must be sure that our law enforcement officers are protected from the risks inherent in the job. Based on data collected and recorded by the Department of Justice, protective vests were directly attributable to saving the lives of at least 33 law enforcement and corrections officers in 20 different states in a single year. At least 14 of those life-saving vests had been purchased in part with BVP funds. This bill reauthorizes BVP grants at $25 million per year and extends the authorization through 2020. The bill has the support of all major law enforcement organizations, has been approved by the Senate, and with this authorization, we will immediately be impacting the safety of our law enforcement officers. Law enforcement officers across the United States put their lives on the line every day to protect their communities and fellow citizens. As they continually make sacrifices for us, we must ensure that we provide them with resources to protect their lives as they protect ours. Today's approval of legislation reauthorizing a critical bulletproof vest grant program for state and local law enforcement officers will save lives. I want to thank Representative Lobiondo and Senate Judiciary Committee Ranking Member Leahy for their work on this issue and dedication to our nation's law enforcement officers. And I urge my colleagues to support this legislation. It's now my pleasure to recognize the ranking member of the committee, the gentleman from Michigan, Mr. Conyers, for his opening statement.
Thank you, Chairman Goodlatte. Members of the committee, S-125, the Bulletproof Vest Partnership Grant Program, would provide matching grants to state, local, and tribal law enforcement agencies so that they can purchase bullet-resistant vests for their officers. There are several reasons for supporting this measure. To begin with, S-125 will facilitate the provision of critical protection to law enforcement officers who risk their lives while patrolling our communities. While some of the approximately 800,000 law enforcement officers throughout the United States do have some form of bullet resistance armor, far too many of these brave men and women are not afforded the same protection due to state and local budget constraints. In 1998, the Bulletproof Vest Partnership Grant Program was established to assist state and local enforcement agencies in obtaining the necessary protective equipment to safeguard the lives of their officers. Since it was established, this program has provided more than 1 million officers with life-saving vests. During the past 30 years, bullet-resistant vests have saved the lives of more than 3,000 law enforcement officers. In 2012, for example, these vests were credited with saving the lives of 33 law enforcement officers in 20 different states. 14 of these vests were purchased with the help of Bulletproof Vest Partnership Program funds. In my home district, the police departments for the cities of Highland Park, Melvindale, Romulus City, and Wayne County have received funds through this important program. Second, the bill addresses a real need. Many local departments, police departments, as a result of budget cuts, just simply cannot afford to bring or to provide up-to-date protective equipment for their officers. The Bulletproof Vest Partnership Program is critical because it provides up to 50% of the cost for an officer's new armor vest. The officer's department, in turn, pays the remaining costs. Importantly, smaller police departments that service areas with less than 100,000 residents receive priority funding under this measure. And lastly, S-125 responds to the critical concern that bullet-resistant vests, to achieve their intended goal of protecting an officer from life-threatening gunshots, must meet certain standards. To this end, the bill requires a law enforcement agency to purchase body armor that meets strict performance standards set by the National Institute of Justice. Additionally, the agency must have a policy that encourages officers to wear their vests while on duty, and the agency must ensure that these vests properly fit female officers. In closing, I note that we expect our officers to protect those who are unable to protect themselves. To do so, however, we must ensure that these brave men and women are themselves protected. Accordingly, I urge support for this bill. I thank the chair and yield back the balance of my time.
Without objection, all other members' opening statements will be made a part of the record. For the purpose of the gentleman from Texas seek recognition.
Mr. Chair, I move to strike the last word.
Gentleman is recognized for 5 minutes.
I thank the chairman. Thank you for bringing up this bill, the Bulletproof Vest Partnership Bill. A week ago today in Houston, Texas, Harris County Deputy Constable Alden Compton had a traffic stop. After he'd finished the traffic stop, he was at a convenience store talking to a trainee with the constable's office, whereupon he is encountered, or a criminal started firing at the deputy. He was shot 6 times. He survived because he had a bulletproof vest on. Saved 1 life, and I'm sure Deputy Constable Compton is grateful that he had the opportunity to wear a vest. Many law enforcement agencies don't have them, they can't afford them, and so I totally support this legislation on behalf of the peace officers of the Houston area and other peace officers who wear these vests to protect them from these criminals that are roaming our streets. So I yield back.
Chair thanks the gentleman. Are there any amendments to S-125? A reporting quorum being present, the question is on the motion to report the bill S-125 favorably to the House. Those in favor say aye. Aye. Those opposed, no. The ayes have it, and the bill is ordered reported favorably. Members will have 2 days to submit views. Pursuant to notice, I now call up H.R. 3380 for purposes of markup and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 3380, to provide the Department of Justice with additional tools to target extraterritorial drug trafficking activity and for other purposes.
Without objection, the bill is considered as read and open for amendment at any point, and I'll begin by recognizing myself for an opening statement. Today we consider H.R. 3380, the Transnational Drug Trafficking Act of 2015, which was introduced by our Judiciary Committee colleagues Tom Marino of Pennsylvania and Pedro Pierluisi of Puerto Rico. This legislation makes important changes to our federal drug laws to ensure that law enforcement has the tools it needs to combat extraterritorial drug trafficking. It also is the first bill this committee will consider as part of the House's comprehensive response to the ongoing opioid epidemic that plagues our nation. It is often said in Washington that federal law cannot keep up with lawbreakers. H.R. 3380 is a timely and appropriate response to that reality. In recent years, drug organizations in Colombia, Peru, and other Central American source other Central and South American source nations have increasingly relied upon Mexican drug trafficking organizations to import their narcotics into the United States. Under current law, it is very difficult for federal prosecutors to make cases against such source nation manufacturers, wholesale distributors, brokers, and transporters, since direct evidence of their intent that the drugs are bound for the United States is difficult, if not impossible, to develop. The result is that source nation malefactors who produce and distribute illegal narcotics escape prosecution under U.S. law because they feign ignorance of the drug's ultimate destination. This has happened with increasing regularity over the past several years, and it is Congress's responsibility to address this problem. H.R. 3380 does so by amending the Controlled Substances Import and Export Act to stipulate that when a narcotics trafficker or manufacturer has a reasonable cause to believe that the illegal narcotics he produces or traffics will be sent into the United States, then the U.S. may prosecute him. This amendment will permit federal prosecutors to pursue extraterritorial drug traffickers who are not directly smuggling drugs into the United States, but who facilitate it. H.R. 3380 also amends the Import-Export Act to address the increasingly prevalent problem of trafficking in listed chemicals, which are chemicals regulated by the DEA because they are used in the manufacture of controlled substances. During a recent CODEL to South and Central America, several of my colleagues and I heard firsthand how drug trafficking organizations have relied on shadowy chemical suppliers in the manufacture of methamphetamine, heroin, cocaine, and other dangerous narcotics. In H.R. 3380, we would enable federal prosecutors to reach chemical traffickers who knowingly facilitate and benefit from the illicit production and smuggling of listed chemicals. Both of these amendments will allow federal law enforcement to go after not the lowly drug mules moving drugs into the United States, but the criminals who facilitate at a high level within the source nation the trafficking of narcotics and precursor chemicals into the United States. As one law enforcement official has said to me, it is better to fight this battle there than here. In addition to these important reforms, H.R. 3380 also amends the criminal counterfeit law to include an intent requirement for trafficking in counterfeit drugs. Throughout my chairmanship, I have paid special attention to the need for appropriate mens rea protections in federal law and have stressed that Congress must speak clearly on the matter when writing criminal law. Though this is a small change, it is an important one, as are the other changes in this legislation, and I am pleased to support them today. H.R. 3380 is bipartisan, bicameral, responsible legislation. Earlier this year, the Senate passed, by unanimous consent, an identical bill sponsored by Democratic Senator Dianne Feinstein of California. It is time for the House to act. I urge my colleagues to support this important legislation. And it's now my pleasure to recognize the ranking member of the committee, the gentleman from Michigan, Mr. Conyers, for his opening statement.
Thank you, Chairman Goodlatte. Members of the committee, H.R. 3380, the Transnational Drug Trafficking Act, is intended to make it easier for prosecutors to convict foreign drug traffickers who are responsible for importing into the United States illegal drugs and chemicals used to make those drugs. Drug abuse has taken a devastating toll on communities across our nation. It is clear that we must take steps to reduce the flow of illegal drugs into the United States. 3380 attempts to address this problem by amending Section 959 of the Controlled Substances Act. Section 959 makes it a federal offense for individuals to manufacture or to distribute drugs or chemicals used to manufacture drugs with the intent or knowledge that their products will be unlawfully imported into the United States. A conviction under this statute may result in a mandatory minimum sentence of 5 or 10 years, depending on the quantity and type of substance involved. Under current Section 959, a foreign drug kingpin can avoid prosecution by simply feigning ignorance as to the ultimate destination of their product. Prosecutors who lack direct evidence that a foreign drug kingpin actually knew their product was going to be shipped to the United States or intended for their product to be shipped to the United States may be unable to convict the kingpin under Section 959. H.R. 3380 is meant to better facilitate the conviction of these criminals, and I strongly support the bill's intent to help stem the flow of drugs into our nation. But I am concerned that H.R. 3380 accomplishes this goal by lowering the level of intent a prosecutor must prove to reasonable cause to believe. As a result of the bill's reduced mens rea standard, the legislation would subject more individuals to mandatory minimum sentences, which, of course, concerns me greatly. Accordingly, I intend to offer an amendment to address this issue while not harming in any way the important goals of this bill. I also note that H.R. 3380 adds a knowledge requirement to Section 2320 of Title 18. As a result of this amendment, a prosecutor must prove that an individual trafficking in a drug with a counterfeit mark knew that the drug had a counterfeit mark in order to obtain a conviction under that provision. I have no objection to this aspect of the bill. I look forward to our discussion of H.R. 3380, and I yield back, Mr. Chairman, the balance of my time. Thank you.
Without objection, all other members' opening statements will be made a part of the record. Are there amendments to H.R. 3380? For purposes, the gentleman from Pennsylvania seek recognition.
Move to strike last word.
Gentleman is recognized for 5 minutes.
Thank you. Mr. Chairman, I want to thank you for bringing this bill up today. I also would like to thank my colleague, Congressman Pierluisi, for sponsoring this legislation with me. The chairman is correct in recognizing that federal law often fails to keep up with the lawbreakers. As a former prosecutor, I am currently and acutely aware of this. My experiences have shown that when there is a hole in the law, sophisticated criminal organizations will find ways to use it. I would like to make a key point about the purpose of this bill and the type of organizations it targets. Our focus through this bill is sophisticated, often multinational organizations with expansive networks of distribution. These operations produce drugs primarily in South and Central America with the intent of distributing them into much more distant countries. We do not intend to confront petty dealers or low-level smugglers who may lie at the narcotics' final destination. Federal law already gives law enforcement tools for these concerns, and I want to reiterate that. Federal law already gives law enforcement tools for these concerns. Our bill focuses on their superiors, the presidents, chief executives, and managers located outside of the United States, source nations where narcotics are made. Under their direction, drugs are manufactured and packaged for illegal wholesale distribution in these countries in South and Central America. In many instances, the final destination is the United States. But due to a hole in current law, the ones who make these drugs and send them to our communities can evade prosecution. The law allows them to claim ignorance of an intent to do harm here and simply put the blame on those who do their bidding. Without these source nation manufacturers and wholesalers, the flow of deadly narcotics across our borders would be greatly reduced. My district and many of my colleagues' district face a growing heroin epidemic. Our upcoming efforts to counter this crisis are crucial to stopping it. The bill removes the shield by which the manufacturers of death and addiction have evaded justice. The Senate has already acted to bring these criminals to justice. An identical bipartisan bill sponsored by Senators Feinstein and Grassley passed with the unanimous consent of all senators just last year. I urge my colleagues to support the bill in its current form so that it can quickly move on into law. Thank you again for the time, and I yield back the remainder.
Chair thanks gentleman. For what purposes the gentleman from Puerto Rico seek?
I move to strike the last word.
Gentleman's recognized for 5 minutes.
Thank you. I want to begin by thanking Congressman Marino for working with me on this bipartisan bill, which is designed to remove an unwarranted obstacle to the successful prosecution of leaders of international drug cartels based in foreign countries. I also want to thank Chairman Goodlatte for scheduling this bill for a markup. I will briefly explain the problem we're trying to address with the bill, and then explain why I believe any amendment to the bill, however well-intentioned, is unnecessary, based on unfounded concerns, and will complicate the effort to enact the bill into law. Let me begin by noting that this bill has been approved by the Senate 4 times since 2011, 3 times by unanimous consent, and once in the form of an amendment to another bill, where the amendment was approved by a vote of 94-0. The Senate version of the bill, which is identical to this bill, is sponsored by Senator Feinstein of California and Senator Grassley of Iowa, who lead the Senate caucus on international narcotics control. The bill was carefully vetted with Senator Leahy of Vermont, Senator Durbin of Illinois, and other senators who care deeply about balancing public safety and due process for defendants. The bill has been endorsed by the Department of Justice. The background of the bill is as follows. South America is the primary source of the cocaine and a significant amount of the heroin that is illegally imported into the United States. Often, drug trafficking organizations based in South America manufacture a controlled substance and transport it to Central America, Mexico, and the Caribbean, where other trafficking organizations based in Mexico or other countries take possession of the controlled substance and then import it into the United States. Under current federal law, in order to prosecute a cartel leader in federal court in the United States for his or her extraterritorial activities under the so-called long arms statute, federal prosecutors must provide direct proof that the defendant manufactured or distributed a controlled substance and intended or knew that the controlled substance would be illegally imported into the United States. In the past, when Colombian cartels controlled the entire transport route from South America to the United States, it was not difficult to obtain evidence that a defendant knew the ultimate destination of the drug. However, with the rise of Mexican and other cartels as intermediaries, it has become much more difficult to prove that leaders of South American drug trafficking organizations knew the ultimate destination of the drugs they sold to their Mexican and Caribbean customers. Indeed, sophisticated cartel leaders understand how cases are prosecuted in the United States and often avoid discussion of the final destination of their drug shipments in order to facilitate the U.S. prosecution of high-level leaders of international drug trafficking organizations. Our bill amends 21 U.S.C. Section 959 to impose penalties for extraterritorial drug trafficking when the prosecution can prove that the defendant manufactured or distributed a controlled substance and intended, knew, and this is the only change, had reasonable cause to believe that the controlled substance would be imported into the United States. For instance, if the drug transaction is financed using U.S. dollars, the package branding suggests a U.S. destination, or the drug route suggests that the ultimate destination is the United States, then DOJ would be able to present that evidence to demonstrate that the traffickers violated the drug trafficking long arms statute. Likewise, our bill amends 21 U.S.C. Section 959 to impose penalties on producers of precursor chemicals from other countries who intended or knew that these chemicals would be used to manufacture illegal drugs and who intended, knew, or again, this is the only change, had reasonable cause to believe that the drug would be imported into the United States. Let me quickly address the ranking member's concerns and in the time remaining, and I might expand my comments later on at this markup, I do believe that I'm the first one who has concerns with minimum sentencing guidelines and minimum sentences and so on. This bill doesn't address that at all. It doesn't change the legal framework in terms of minimum sentences, and it is not expanding the minimum sentences in America. The bill is intended to assist prosecutors, federal prosecutors, in using the long-arm statute. The bill also doesn't change the mens rea requirement on the underlying offense. It simply deals with the level of intent required to exercise personal jurisdiction over these traffickers. And obviously, DOJ is not going to be extraditing mules or low-level traffickers. They will be targeting the leaders and managers of the drug trafficking organizations that are plaguing us and affecting our quality of life. I yield back.
Chair thanks the gentleman. Are there amendments to H.R. 3380? For purpose, the gentleman from Rhode Island seek recognition.
I move to strike the last word.
Gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. I wish to speak in support of Mr. Conyers' amendment. As everyone knows, mandatory minimums remove the ability of the trial court to consider the facts and circumstances of the particular defendant before the court. Mr. Conyers' amendment is intended to address an unforeseen consequence of the existing legislation. We've all seen too often the severe and unfair consequences of mandatory minimum sentences that are imposed regardless of the particular circumstances of the case or the defendant. And to reduce the burden of proof and continue this practice would mean that mandatory sentences would be imposed coupled with a reduction of mens rea, and so that we will make this situation even more, I think, troublesome. And we'll see more instances of individuals who are subjected to mandatory minimum sentences who are not intended to be covered by the law. So I think what the amendment does, it will ensure that this reduced mens rea standard applies to leaders and organizers and drug kingpins as it should. And I think that's the intention of the legislation. And so in fact, ensuring that there are not unintended consequences of swooping in a whole new group of individuals who may be low-level offenders into very severe mandatory minimums because we've reduced the standard significantly, the mens rea requirement, which I think is not the intention. And so I strongly support Mr. Conyers' amendment and urge my colleagues to do the same, and I yield back.
For purpose, the gentleman from Georgia seek recognition.
Move to strike the last word.
Gentleman is recognized for 5 minutes.
And I speak in support of the amendment. I would ask the authors of this legislation whether or not this reduced mens rea requirement would apply to lower-level domestic co-conspirators.
No, I haven't.
And I would also ask whether or not, in light of the sentencing guidelines, which provide for base offense levels, and in conspiracy cases, one co-conspirator down line is responsible for the total amount of the conspiracy, including people upline. So in other words, a domestic co-defendant charged in a conspiracy with a international drug kingpin, whether or not this legislation would reduce the mens rea requirement for that domestic co-defendant lower level, and whether or not the liability under the sentencing guidelines to a downline co-conspirator would cause that co-conspirator to be responsible or liable for the total amount of the drug conspiracy.
Would the gentleman yield?
Yes, I would.
This amendment has not been introduced yet, so perhaps we should go ahead and get the amendment introduced. And
Okay, well then, my question is a little premature, but I would hate to have to restate it, so but I will.
for what purpose does the gentleman from Michigan seek recognition?
I offer an amendment to, and it's at the desk, Mr. Chairman.
Clerk will report the amendment.
Amendment to H.R. 3380 offered by Mr. Conyers. Page 2, line 7, strike and.
Without objection, the amendment is considered as read, and the gentleman is recognized for 5 minutes on his amendment.
I thank the chair. Members of the committee, I am overwhelmed by your anticipation of this amendment, and I've never had one that was supported before it was introduced, so I'd like the record to reflect that I am very proudly aware of this honor. Members, I offer this amendment to adjust the scope of H.R. 3380 in light of the fact that the bill would in effect expand the use of mandatory minimum penalties. It does this by reducing the intent requirement in section 959 of the Controlled Substances Act from intent or knowledge that drugs were imported into the United States to a reasonable cause to believe that the drugs were destined for the United States. Now, while this change may make sense in the abstract, I have concerns based on the application of penalties under Section 9960 of the Controlled Substances Act, which include potential mandatory minimum sentences. By lowering the level of intent that a prosecutor must prove, we will subject more people to mandatory minimum sentences. As a matter of principle, it's my view, and I think a growing number of members on the committee, that mandatory minimum sentences are unjust and unwise. Their application is plagued with problems and has led to extraordinary injustice, prison overcrowding, and increasing costs to taxpayers. Although I appreciate the efforts of the chairman of this committee and my colleagues on this committee to work together to reduce some mandatory minimum sentences and expand safety valves for them, I remain committed to exposing their expansion, even indirectly. While I'd prefer to eliminate the mandatory minimums altogether, my amendment does not go that far, but instead takes an approach that I believe is consistent with the goals of this bill. I propose that the reduction of the intent requirement to reasonable cause to believe only be applied to those who are leaders or organizers of the criminal activity we're seeking to address. This is also consistent with the original intent of mandatory minimum sentences, that they be reserved for application to kingpins. The application to leaders or organizers of an organization of 5 or more members is based on provisions that already exist in the federal sentencing guidelines. These guidelines allow adjustments to offense levels based on the role a defendant played or the defendant's level of participation in the commission of an offense. Aggravating role adjustments are assigned level increases. Organizers and leaders of criminal activity that involve 5 or more participants receive the greatest increase in levels. Designation of an organizational or leadership role is not based merely on titles. The courts are instructed to consider the actual conduct of the defendant to determine if the defendant was an organizer or a leader. The conduct to be considered includes the following considerations: the exercise of decision-making authority, the nature of participation in the commission of the offense, the recruitment of other participants, the right to claim a larger share of the profits, the degree of participation in planning or organizing the offense, the nature and scope of the offense, and finally, the degree of authority and control the defendant exerted over others. Now, members, my amendment would not mean that lower-level offenders are not liable under the statute, but it would simply preserve the status quo for anyone who is not an organizer or leader and reserve the lower intent requirement for the true kingpins. By using standard language from the guidelines, my amendment preserves the intended application of the legislation, while recognizing that mandatory minimums should be used in more limited circumstances. I think we will arrive at a reasonable application of the amendment. May I commend the sponsors of this bill, Mr. Marino and Mr. Pierluisi, for their work on this legislation. But additionally, I ask that they and my colleagues support my amendment. I thank the chair and yield back the balance of my time.
The chair thanks the gentleman and recognizes himself. I must oppose the amendment, however. The intent of H.R. 3380 is to give the U.S. government the ability to pursue and prosecute members of a drug trafficking organization who are located in the source nation, specifically the criminals who are cutting, smuggling, brokering, and supplying for sale illicit narcotics. These individuals have thus far been able to evade prosecution for their illicit activity, but have benefited handsomely from it. Indeed, many drug traffickers have become so familiar with U.S. drug statutes that they know not to discuss things like the ultimate destination of a drug shipment. This amendment seeks to limit the application of this legislation. That would have the effect of protecting Colombian, Peruvian, Honduran, Salvadoran, Guatemalan, and other foreign nationals who are members of a drug trafficking organization. In doing so, this amendment would gut the core purpose of the bill, which is to target these drug trafficking organizations at their heart. I remind my colleagues that this legislation passed the Senate by unanimous consent earlier this year. The concerns highlighted in this amendment did not cause a single senator to oppose the bill. I oppose the amendment, and I urge my colleagues to do so as well. The question occurs on the amendment offered by the gentleman from Michigan. All those in favor respond by saying aye.
Aye.
Those
Mr. Chairman.
opposed? The gentleman's request comes in the middle of a vote. I think his request is not timely. All those opposed to the amendment respond by saying no.
Mr. Chairman, point of order. Point of order.
Gentleman will state his point of order.
Prior to a vote being called on a particular amendment, prior to a vote actually having taken place and a member asks for time to speak on the amendment, is it then too late for the chair to entertain that request to strike the last word?
The chair will advise the gentleman that we were halfway through a vote. However, in comedy, I will recognize the gentleman for his remarks. But I would ask him in the future, when we pause and there's opportunity given for members to request time, that he take advantage of that time before we move into a vote.
Thank you, Mr. Chairman, and I appreciate your forbearance. I have the question that I asked before. about this amendment, which I rise in support of. And the question applies to the overall bill itself, even without amendment. And the question is this: when a international drug trafficker, a kingpin, an organizer, or a leader, which we refer to as a kingpin, is accused in an indictment that involves U.S. citizens operating here in the United States who are alleged to be a part of the conspiracy with the kingpin, the foreign kingpin, does the lowering of the mens rea requirement apply to those domestic downline co-conspirators? And also, if those conspirators should be convicted, do the sentencing guidelines, which include base offense levels, which anticipates the amount of a drug conspiracy, is the total amount of the drugs distributed by that kingpin attributable to the people downline, domestic drug dealers who are caught up and convicted in that conspiracy?
Would the gentleman yield?
Yes.
The answer to your question is no, it does not apply to those U.S. citizen downline participants in the organization, because this is an amendment to the Import-Export Act and only applies to non-citizens.
And what about the amount of the drug conspiracy for sentencing purposes?
Again, since it only applies to non-citizens, I believe that it would not apply to U.S. citizens.
The chair stands by its previous.
The chair stands by his answer.
All right, thank you.
All right. The question occurs on the question on the amendment offered by the gentleman from Michigan. Again, all those in favor respond by saying aye.
Aye.
Those opposed, no. No. Opinion of the chair, the noes have it. The amendment is not agreed to.
Could I get a recorded vote?
The recorded vote is
Chairman.
requested, and the clerk will call the roll.
Thank you.
Mr. Goodlatte?
No.
Mr. Goodlatte votes no. Mr. Sensenbrenner? Mr. Sensenbrenner votes no. Mr. Smith? Mr. Shabbat? Mr. Isa? Mr. Forbes? Mr. King? Mr. King votes no. Mr. Franks? Mr. Franks votes no. Mr. Gomert? Mr. Jordan? Mr. Jordan votes no. Mr. Poe? Mr. Chaffetz? Mr. Marino? Mr. Marino votes no. Mr. Gowdy? Mr. Labrador? Yes. Mr. Labrador votes yes. Mr. Farenthold? Mr. Collins? Mr. Collins votes no. Mr. DeSantis? Mr. DeSantis votes no. Ms. Walters? Ms. Walters votes no. Mr. Buck? Mr. Buck votes no. Mr. Ratcliffe? Mr. Trott? Mr. Trott votes no. Mr. Bishop? Mr. Bishop votes no. Mr. Conyers?
Aye.
Mr. Conyers votes aye. Mr. Nadler? Ms. Lofgren? Ms. Jackson Lee? Mr. Cohen? Mr. Johnson? Mr. Johnson votes aye. Mr. Pierluisi? Mr. Pierluisi votes no. Ms. Chu? Mr. Deutsch? Mr. Gutierrez? Ms. Bass? Mr. Richmond? Ms. Delbene? Mr. Jeffries? Mr. Jeffries votes aye. Mr. Cicilline? Mr. Cicilline votes aye. Mr. Peters? Mr. Peters votes no.
The gentleman from Virginia, Mr. Forbes.
Mr. Forbes votes no.
The gentlewoman from California, Ms. Chu.
Ms. Chu votes aye.
Has every member voted who wishes to vote? The gentleman from South Carolina, Mr. Gowdy.
Mr. Gowdy votes no.
The clerk will report.
Mr. Chairman, 6 members voted aye, 16 members voted no.
And the amendment is not agreed to. Are there further amendments to H.R. 3380? The reporting quorum being present, the question is on the motion to report the bill H.R. 3380 favorably to the House. Those in favor respond by saying aye. Aye. Those opposed, no. In the opinion of the chair, the ayes have it, and the bill is ordered reported favorably. Members will have 2 days to submit views. Pursuant to notice, I now call up H.R. 4985 for purposes of markup and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 4985 to amend the Foreign Narcotics Kingpin Designation Act to protect classified information in federal court challenges.
Without objection, the bill is considered as read and open for amendment at any point, and I'll begin by recognizing myself for an opening statement. Nearly 21 years ago, the President issued an executive order to deal with the unusual and extraordinary threat to our national security, foreign policy, and economy posed by narcotics traffickers centered in Colombia. The actions of these narcotics traffickers produced an extreme level of violence, corruption, and harm in the United States and abroad. The following year, the U.S. Department of the Treasury's Office of Foreign Assets Control issued the Narcotics Trafficking Sanctions Regulations, which implemented that executive order. These regulations blocked the property and interests in property in the United States or in the possession or control of U.S. persons or anyone determined to be a specially designated narcotics trafficker. After OFAC had demonstrated its success in using its authorities under the executive order, Congress decided that similar authorities should be used worldwide. Congress passed the Foreign Narcotics Kingpin Designation Act. In December 3, 1999, the President signed into law the Kingpin Act, which applied to the same types of authority that were previously used against Colombian narcotics traffickers to traffickers worldwide. The names of persons and entities designated pursuant to the Kingpin Act, whose property and interests in property are therefore blocked, are published in the Federal Register and incorporated into the list of specially designated nationals and blocked persons. The SDN list is available through the OFAC's website. Whenever OFAC makes a designation, the list is updated and distributed in various forms to banks and financial institutions. Since 2000, OFAC has designated more than 1,800 persons under the Kingpin Act, all of whom are non-U.S. persons. Listed individuals are permitted to seek removal of the OFAC sanctions via a delisting process and challenge adverse findings in federal court. OFAC's designations under both the International Emergency Economic Powers Act and the Kingpin Act are often based upon classified information. Under the International Emergency Economic Powers Act, OFAC is permitted to submit such information ex parte and in camera to a court. However, the Kingpin Act does not contain such a mechanism to protect classified information from release during a delisting process. That means OFAC may lose the opportunity to designate a high-level drug kingpin because it cannot risk the disclosure of classified information. H.R. 4985 would address this issue by ensuring that OFAC can submit classified information to defend its designations ex parte and in camera, thereby harmonizing the Kingpin Act with the OFAC authorities under IEEPA and protecting classified information from disclosure. Such protections are critical to defend the Kingpin Act designations based upon classified information, and I urge my colleagues to support this important measure. It's now my pleasure to recognize the ranking member, Mr. Conyers, for his opening statement.
Thank you, Mr. Chairman. Members of the committee, The Kingpin Designation Improvement Act amends the Foreign Narcotics Kingpin Designation Act to ensure classified information is not disclosed when individuals challenge their designation as kingpins under this act. Our law enforcement agencies should have necessary legal tools to enforce sanctions against individuals who traffic significant quantities of illegal narcotics internationally. I support 4985 because it appropriately targets the actual leaders and organizers of foreign-based drug cartels who traffic massive amounts of illegal narcotics into our communities. The bill does not apply to individuals who have committed low-level, nonviolent drug offenses, nor does this measure further the misguided application of mandatory minimum sentences to those who commit such offenses. H.R. 4985 will effectively prevent individuals who engage in significant foreign narcotics trafficking to obtain access to United States banks and other financial systems. Equally important, this bill maintains the required process the government must adhere to when making kingpin designations. To that end, 5 separate departments must coordinate and confer with one another prior to making such designations. Included in this decision-making process are the Secretary of the Treasury, the Attorney General, the Secretary of State, the Secretary of Defense, the Secretary of Homeland Security, and the Director of the CIA. Additionally, the President must report annually to our committee, among others, on the foreign persons selected for designation. Given these safeguards, the changes made by this bill will help ensure that individuals engaged in global narcotics trafficking cannot hide behind their ill-gotten gains in our nation's financial system. Accordingly, I urge support for H.R. 4985. I thank the chair and yield back the balance of my time.
Thank you, Mr. Conyers. Without objection, all other members' opening statements will be made a part of the record. Are there any amendments to H.R. 4985? A reporting quorum being present, the question is on the motion to report the bill H.R. 4985 favorably to the House. Those in favor will respond by saying aye.
Aye.
Those opposed, no. The ayes have it, and the bill is ordered reported favorably. Members will have 2 days to submit views. This concludes our business today. I thank all the members for their expeditious work on this legislation and thank them for attending. The markup is adjourned.